हाँ जी सर, संविधान दिवस जी सर।
संविधान वाला ना।
जी
तो
जी
मैं
सर।
प्रोग्रामों से मैं क्लैश कर जाता हूँ, कभी कभी लीगल एड का हो जाता है
मैम
ना।
वी आर लाइव।
Okay, okay. Good morning, ladies and gentlemen. Welcome to Amity University. Amity University, a research and innovation-driven university.
मेरा
Amity University is a leading education group having grade A plus accreditation by the National Accreditation Body of Government of India. As of today, the Amity Education Group of India has over 150,000 students studying across 1,000 acres of high-tech campus and 250 educational programs. Amity Education Group has 12 international campuses and global K-12 preschools across India. In order to be a truly global university, Amity University has set up 12 international campuses located in US, UK, Dubai, Abu Dhabi, Singapore, Mauritius, Romania, South Africa, Hong Kong, mainland China, and many more to come. Around 1,100 patents are filed by the faculty, and about 300 government-funded research projects are being worked upon. Ladies and gentlemen, welcome to Amity University, a research and innovation-driven university. Welcome to this colloquium, which is hosted by Amity Legal Aid and Literacy Committee at Amity Law School, Noida. It's my profound privilege to have with us Honorable Justice Rajesh Tandon sir amongst all other panelists who've joined us from different parts of the country. And today, what we are going to deliberate upon is Samvidhan Diwas, Samvidhan Sarvopari. So, ladies and gentlemen, in order to begin with this colloquium, let us take the blessings of the goddess so that we invoke, so that the prayers that we invoke blesses us and that we all be victorious. Having said so, I'll request Maqsood sir to play the Saraswati Vandana video.
मुनियों ने समझी है गुणियों ने जानी, वेदों की भाषा पुराणों की वाणी। मुनियों ने समझी है गुणियों ने जानी, वेदों की भाषा पुराणों की वाणी। हम भी तो समझे, हम भी तो जाने, विद्या का हमको अधिकार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ। हे शारदे माँ, हे शारदे माँ, अज्ञानता से हमें तार दे माँ।
Thank you so much, Maqsood sir, for presenting that video. Well, ladies and gentlemen, what a proud day. अब मुझे ये बताते हुए भी बहुत हर्ष हो रहा है कि आज इस कोलॉक्वियम में हमारे जितने भी पैनलिस्ट हैं, इनफैक्ट हम सभी एज सिटीजन्स ऑफ आवर कंट्री, हम सभी अपने संविधान के संरक्षक हैं। तो और हमें इस लीगेसी को आगे भी ले जाना है क्योंकि भारत हमेशा से ही विश्व गुरु रहा है. So a little bit about the history of our constitution and why do we celebrate this day? So the Constitution of India 1950, was drafted by the Constituent Assembly from 1946 to 1950, and that it was on 26th of November 1949 that India's Constituent Assembly adopted its constitution, and as of January 26, 1950, Republic Day came into effect, and that, yes, Dr. B.R. Ambedkar was the chairman of the drafting committee of the Constituent Assembly, and he played a crucial role in the framing of the Indian Constitution. So, to acknowledge the contribution of the framers of the Indian Constitution and to inculcate the prominent constitutional values amongst the people, 26 November is celebrated as the Constitution Day. Welcome all the panelists to this colloquium. I'm so humbled and very much honored that all of you are here. And at Amity University, we all are guided by the values laid down by our founder president, Dr. Ashok K. Chauhan, sir, who believes that all the Amitians are an asset to the society and the committee and the entire world by propagating Vasudhaiva Kutumbakam. Taking no time further, I will now hand it to the moderators of today, Dr. Trapti Vashne and Dr. Pranav Tiwari, in order to moderate the session. Over to you, sir and ma'am.
Thank you, ma'am.
Thank you, ma'am. Thank you, Sumitra, ma'am, for giving me this opportunity. Now, I would like to extend a very warm welcome to our panelist, Honorable Justice Rajesh Tandon, sir. Sir served as a judge of Uttarakhand High Court. He was also the former chairman of Uttarakhand Law Commission. Sir is serving as the additional vice chairman of Amity Judicial Academy and Amity Law Foundation. Rajesh Tandon, sir, is a remarkable individual who has achieved great success in the area of law. He is a true inspiration for many, and we are honored to have him with us. His words of wisdom and encouragement will undoubtedly motivate us and to our students as well. A very warm welcome, sir. Over to you, sir.
Thank you very much. Now, today, I am grateful to Dr. Sumitra Singh, who has collected all the panelists for this function and for this ceremony. I am also thankful to our founder president, Dr. Ashok K. Chauhan, for organizing this Constitution Day program. 26th was a holiday, Sunday. 27th was also holiday. But on 26th, my program was organized on the online also. And on that online, it was relayed by the empty online program on 10 o'clock, 2 p.m. and 4 p.m. And I hope every panelist who is present here must have heard about that Constitution Day program, which I have circulated on 26th of November. Now, I want to say only few things regarding the Constitution Day, the importance of Constitution Day. The importance of Constitution Day, first of all, I pray my naman to all the panelists who are present here. One of my sincere disciple, Dr. Amit Mehrotra, Advocate Amit Mehndiratta is also present. Dr. Tripti Vashne is also present. And Dr. Sumitra, my professor, is also present. Kavita Sharma ji also present. I am thankful for all that. Now, the importance of the Constitution Day is that it has covered the entire background of a human being. I will demonstrate how. In 1949, the Constitution Day has come into force, but it was signed and it was enforced on 26th of January, 26th of November, and therefore 26th of after that it was made applicable from 26th of January, and that was also a Constitution Day, that is also a Republic Day. Therefore, these three dates, 1949 and then November 26th and 26th January, all are the constitutional days, and we must observe for 49 to 50 and this 26th January also. All these days are important days. Now, our constitution has got two that is part 3 and part 4. Both are very important for a human being. Part 3 deals with the fundamental rights. Part 4 deals with the directive principles of the state policy. Part 3 covers the Article 21, Article 14, 15, 16, and 19. And thereafter, if I come to the directive principles of state policy, that are the duties which have assigned to the individual, which have come up after Article 51, 52, 51A, all are very important. For Article 21, Article 20, if we take the example of Article 21, that is for the human being, that is status symbol is Article 21. And if you look to the preamble of the Constitution provides 4 things. Number 1, that is justice in 4 matters: justice, social, economic, and political, that is one aspect of the matter; liberty of thought, expression, that is secondary thing; equality of status; fraternity, assuring the dignity of the individual. This is very important. Fraternity, assuring the dignity of the individual. Now, these are the 4 things are there: justice, liberty, equality, and fraternity. Now, if we look to the justice, then Article 21 comes into play. For that purpose, every justice has to be done with everybody. Now, I'll demonstrate before you what are the justice procedure also. But justice has to be done with everybody. Now then, fraternity, that is assuring the dignity of the individual. Nowadays, dignity has become very important because of the fact that Human Rights Act, that is the Protection of Human Rights Act, has also intervened in the fraternity. That he has also said under Section 2D of the Human Rights Act that the dignity is supreme. For dignity, everything has to be done. Therefore, the dignity and justice, both if you combine itself, then I come to Article 39A. I will, since the time is not much greater, therefore I will confine myself to the only problems which are in showing Article 39A, that is equal justice and free legal aid. The state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in a particular provide legal aid by suitable legislation or schemes in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. I have just read before you the preamble also. Preamble says justice, social, economic, and political. And 39A is, and this preamble takes, both are the similar, and just preamble has said justice, economic. Then Article 39A has come into play, that is, nobody shall be denied any citizens for reason of economic or other disabilities. Therefore, economic disabilities means that no one shall be deprived of legal aid by any of these courts of law, by anybody. Now, I am glad that our founder president, Dr. Ashok K. Chauhan, has opened the legal enumeraries, like Dr. Sumitra Chauhan in the legal aid, Dr. Aditya Tomar as a legal aid chairman, and all that. That is the foundation of Dr. Ashok K. Chauhan in the MIT University. And I am the supporting pillar for all these things. and whatever possible, I am trying to make a foundation more strong. And therefore, Article 39A provides the speedy justice, social, economic, and nobody shall be deprived with the economic reasons. Now, therefore, under Article 39A, the Supreme Court has formed a legal services authorities. Now, you have seen this in, operation of the legal system promote justice on a basis of equal opportunity and shall in particular provide a free legal aid by suitable legislation. Now, suitable legislation is Legal Services Authorities Act. And when the Legal Services Authorities Act has come, it has three-tier immunities: central government, state government, and the district court opportunities. Now, the central government provides the legal aid by providing the Lok Adalat and all that. And the state government also provides the free legal aid to Lok Adalat by operating the Lok Adalat and all that. And third is the district level. Now, the question is whether this Article 39A has attained its finality, whether its implementation is required or the implementation has not been done at all. Suppose a legal aid clinic is there and the advocates are working there, whether they are working for the that poor persons who have no money at all. There is none to look after it. Therefore, the question arises as to what will be the effect of the Act, Legal Services Authorities Act, and what will be effect of Article 39A on the eve of our Constitution Day. We have to decide, and we have also to promote that let the Article 39A or the Legal Services Authority Act must be implemented. If it is implemented, then every poor can get the decision. Every poor man can get these suggestions or advices. Otherwise, it will be on only plain paper. Therefore, my suggestion is that for Article 39A and for Legal Services Authority Act, the government should do something to organize the legal camps by taking the retired judges of the Supreme Court, retired judges of the High Court, or the retired district judges, so that they may get the matters decided at an early date. Otherwise, the court has much plenty of matters and the court has no time at all. And therefore, these Lok Adalat Acts under Article 39A of this Legal Services Authority Act has to be utilized, must be implemented. Otherwise, all will be in a plain paper. And therefore, with this symposium, my suggestion is that the Legal Services Authority Act should be our Professor Dr. Sumitra Singh will write to the government or to our Dr. Ashok K. Chauhan, founder president, that he should also write on the basis of the MIT University or whatever directions be given, that at every universities there must be a legal clinics where the advocate should work, and the government should give the power to that, so that they may also do the Lok Adalat cases, and the legal aid clinic of the universities should be conferred the power to deal with the local Adalat matters, and so that all the motor vehicles cases and all that may be decided at early date. These are my submissions. The rest will be elaborated by Praveen Tiwari, Amit Mehndiratta, Rupam Haridwar, or Dr. Sumitra Singh, Trapti ji, and all will be elaborating on that. But the today's direction of mine is that Article 39A and Legal Services Authorities Act must be implemented, and all the universities may be given the legal aid clinic power, and also they may also hold the lok adalats for deciding the cases of in the lok adalat itself. Thank you very much.
Thank you,
Thank
Lord.
you.
Very well taken, sir. Your suggestions are definitely, I will write to the government, and we will see how Legal Aid and Literacy Committee can prove as a pivot in this field of ensuring justice for all. Thank you, Lordship. Over to you, Pranav.
Thank you. Thank you very much, sir, for such insightful suggestions on this context. As this constitution stands as a testament to the foresight and collective wisdom of our founding fathers, we would like to move forward into this our discussion towards our another very intellectual speaker, Dr. Shruti Bist, who is advocate on record at Supreme Court of India and president of IEFCI. And it is very fortunate for us to welcome our guest here in this panel, and would request to kindly share her thoughts and opinions on the topic. Ma'am, over to you.
For the introduction. Good morning.
श्रुति जी को नमस्कार. श्रुति जी को नमस्कार.
Good morning to all the panelists.
तो देहरादून में होने वाली थी आज.
मैं सर अभी देहरादून में ही हूँ. मैं यहीं से ज्वाइन.
देहरादून में है. अच्छा अच्छा, वेरी गुड. चलिए ठीक है. तो आज तो वहां आएंगी, आईएमएस में भी आ रही हैं.
सर आईएमएस में फंक्शन है सर. कितने बजे सर?
हैं?
कितने बजे सर इवेंट?
आईएमएस यूनिवर्सिटी में जो आज प्रोग्राम है, तो उसमें भी आ सकती हैं आप 2:30 बजे.
ठीक है सर, मैं ज्वाइन करूंगी.
ठीक है, ओके, ठीक. हाँ.
Thank you, Sumitra, for inviting me for today's wonderful discussion. As today is the Constitution Day, I would like to say that Constitution Day is observed annually on November 26th, that commemorates the momentous adoption of the Constitution by the Constituent Assembly in 1949. Honorable Prime Minister Narendra Modi ji, recognizing its paramount importance, designated this day in 2015 to instill a deeper understanding of our constitutional legacy and honor the pivotal role played by Dr. B.R. Ambedkar, its chief architect. The Constitution, a meticulous synthesis of principles, delineates India as a sovereign, secular, socialist, democratic republic, ensuring citizens' equality, liberty, and justice. The preamble, a poetic proclamation, captures the lofty aspirations that binds the nation. The transformative journey from colonial governance to a self-crafted constitutional framework began in year 1947. B.R. Ambedkar's comprehensive study of over 60 constitutions informed the drafting process, resulting in a document attuned to India's unique needs and conditions. Constitution Day serves as more than a mere commemoration. It is a call to consciously engage with the ideals that shape our democratic identity. It promotes a collective reflections on the rights and responsibilities enshrined within, and challenging us to uphold the dignity of citizens and safeguard the unity and integrity of our diverse nation. It stands as a testament of our shared commitment to constitutional principles and continual evolution of our democratic ethos. In the grand tapestry of our Constitution, Article 21 stands as the guardian of our most sacred values, the right to life and the right to personal liberty. As the cornerstone of our fundamental rights, it resonates with the profound idea that no person, be they citizen or foreigner, shall be deprived of the essence of life or freedom to chart their own destiny except through the hallowed corridors of law. The venerable Supreme Court, in its wisdom, has aptly deemed Article 21 as the heart of the fundamental rights, acknowledging its pivotal role in shaping the contours of justice and fairness in society. It is not merely a legal provision, but a beacon that stimulates the path towards a life of dignity and meaning.
Yes.
Now, as our Honorable Justice Tandon sir has explained over various fundamental rights, we should also focus on what Article 21 is. If I conclude and draw that Article 21 is be more than mere words on a paper, it is a living pulse of our democracy, because it cherishes the freedom, justice, and the pursuit of a life well lived. Now, according to 21 article, protection of life, liberty, and personal liberty, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, right to personal liberty has been, considered as a fundamental right, and I would like to throw on certain important cases like A.K. Gopalan case. In 1950, until 1950, the Article 21 had a bit or narrow scope. In this case, the Supreme Court held that the expression procedure established by law. The Constitution has embodied that British concept of personal liberty rather than the American due process. Apart from it, we have another prominent case of Minka Gandhi. In this case, A.K. Gopalan case was overturned. Here, the Supreme Court said that Article 19 and 21 are not watertight compartment. The ideal of personal liberty in Article 21 has a wide scope, including many rights, and some of which are embodied under Article 19, and thus giving them additional protection. The court also held that a law that comes under Article 21 must satisfy the requirements under Article 19 as well. That means any procedure under the law for deprivation of life or liberty of a person must not be unfair, unreasonable, or arbitrary. So that's the overview of Menka Gandhi judgment. Then there are various other, rights that are covered by Olga Tellis cases, Uni Krishnan cases, and Sunil Batra cases that, ensures that Menka Gandhi case and many more that ensures that, speedy legal trials, right of prisoners, that is all being preserved under Article 21. If we give some list of rights that are preserved, then we have one right to privacy under Article 21, right to go abroad, right to shelter, right against solitary confinements, right to social justice and economic empowerment, right against handcuffing, hanging, protection of cultural heritage, right to
Ma'am, I guess there is some network fluctuation. We are not hearing her.
Oh, कहाँ हो? Where are you? At Lucknow or Rudhipur?
I've returned back last night to Rudrapur. I'm coming to Delhi post lunch.
Okay, अच्छा अच्छा.
I returned back from Lucknow late in the evening. I'll push off for Delhi at 2 o'clock because we have got meetings in the later half in the evening hours. So Chennai lady she has already reached Delhi. We are having meetings with Mr. R.N. Sundaram and Mr. Simple also. He's going to do an appointment for that pertaining to Chennai public, because the development has taken place that our suit restoration application has been dismissed. So this judiciary is under strong pressure of Stalin and the administration. A very important case. I've just come to know the restoration application is also dismissed. Like my suit has gone. So this notice has to be brought before the Honorable Supreme Court that what is happening in India, where we should go for protection of our rights. Are we in a democratic setup? What rights we have, and who is the guardian to protect our rights? If such lower judiciary and higher judiciary is under a strong pressure of the administration, it's very difficult to survive in the country.
Our meeting is on 1st.
Yes, I'll try to get it before that, because they're having meeting with Mr. Sibbal and also with Mr. R.M.B. Sundaram at 10:30 tomorrow. So he's called only.
Okay, now proceed on the subject.
The suit has been dismissed. The
Yeah,
restoration
Lordship, Shruti ma'am is here. Shruti ma'am, would you like to conclude? We were waiting for you. I mean, there was some network problem at your
As
end.
we explained on various articles, I would just like to conclude that there are ample number of cases like DK Basu guidelines to highlight that gives the right, fundamental rights to the prisoners, that if the prisoner has been arrested, then habeas corpus shall apply. Within 24 hours, he will be presented to the magistrate. He shall be given the right to, a legal aid, doctor's assistance, and also explain the reason of the illegal arrest, and his relatives shall be informed. So these are certain important and prominent cases that preserve the fundamental right. So since we are celebrating the Constitution Day, I congratulate all the constitutional makers and the preservers who are upholding our Constitution, and the efforts of MET University to increase the awareness on the Constitution Day regarding the fundamental rights and the Constitution. Thank you.
Thank you so much, Shruti ma'am, for enlightening us. Now, I would like to call Mr. Amit Mandiratta, sir. He is advocate at Supreme Court of India. So, would like to welcome him. A very welcome, sir. Over to you, sir.
Thank you, ma'am. We all have gathered together to celebrate this Constitution Day, which is very relevant. Constitution being the supreme law of the land. As a student, when I was studying law, I have already done a lot of debates regarding Article 44. We passed Article 44 in a parliament. We had an activity as Model Youth Parliament, which was started by the Ministry of Government of Parliamentary Affairs and Government of India. So I had already participated at that time of time in the Articles 44 Uniform Civil Code, as well as the Women Reservation Bill. Constitution being the supreme law of the land, we need to understand the background, because it's such an important subject, because we know whatever Supreme Court says under Article 41, it becomes the law of the land. So I start with the preamble of the Constitution. I had learned so many times, but the Constitution, the preamble says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, to secure to all its citizens justice, social, economic, and political, liberty of thought and expression, belief, equality of status and opportunity, and to promote among them all fraternity, assuring the unity, dignity of the individual and the integrity of the nation." And in our Constituent Assembly on this 26th day of November 1949, we do hereby enact, adopt, and give to ourselves this Constitution. The Constitution is such an important subject, not only for the legal practitioners, but I would say for the law students, because it's a very important subject. As a student and also as a legal practitioner, we have gone through plethora of cases which Honorable Supreme Court has passed. I start with the A.K. Gopalan case. You come to from A.K. Gopalan case, you come to the very important case, the 42nd Amendment, which was brought in the the Constitution, which is known as the mini Constitution. We added the words socialist, secular, and integrated to the preamble. The 10th fundamental duties, which were added to the citizen in Article 51A, Part 4. And very recently, the 101 Amendment brought in 2016, the GST was introduced. So, important facts is that this Constitutional Assembly, under the chairmanship of our first law minister, the head of the drafting of the Constitution, Dr. B.R. Ambedkar, has given such a wonderful Constitution. Though it is said it's a blend of different countries, we have adopted a few of British, we have a few of the Swedish, and we are into a quasi-federal nation. So if we see, one suggestion I would, before I start further on the articles and the judgment, one suggestion I would like to give to the MIT University is that I had told it to my college also, that Constitution being such an important subject, we should ask our students to go into the depth of the Constitution. They should study the Constitution very comprehensively. The books which are written by the authority, Dr. H.M. Sirvai, Mr. Sibarao, and D.D. Basu. This should be included in the curriculum and the syllabus of the students, because I think during the education, whether they are going for a 3-year course or the 5-year course, they should study this Constitution in depth. And this is going to be help them very good in future, whether they are going in the education field or as an academician or in practice. So my suggestion is that this Constitution should be taken very seriously. It's a very important subject, because a lot of things come out of the Constitution. And once we are well versed with that, it really helps in the practicing arena. Now, there are certain judgments which have been passed in the history of India. The Berubari Union case, there's Golaknath case, there's Keshwanand Bharti case, I would tell. The landmark judgment of the Honorable Supreme Court, the 13-judge bench, Keshwanand Bharti case is very important, which each and every student studies like anything, because such an important judgment. The 13-judge bench of the Honorable Supreme Court, Justice Khanna asserted a basic structure doctrine, which says how you can touch the basic structure theory of the Constitution at Article 368, how can you amend the Constitution. So this is a very landmark judgment, 13-judge bench. Keshwanand Bharti was State of Kerala. equally as ma'am said few minutes before, the Article 21, a landmark case of Article 21, which expanded the horizon of Article 21 by the Menka Gandhi's case. What happened is Menka Gandhi's passport was confiscated. She challenged before the Supreme Court that right to privacy. And not only right to privacy, there's certain more articles being added to right to live in pollution-free environment, right to, as Justice Tandon Lordship rightly pointed out, he rightly said, right to live with human dignity, integrity, which is very important. The Chief Justice of India has been repeatedly saying in various seminars that now it is an era that all the lawyers, all the judges, they should understand that honesty, integrity is something of paramount importance. So, the expansion of this Article 21, which has broader created the horizons of Article 20, so many things have been included in Article 21 is also one of the landmark judgments, which we have studied as a student also, as a practitioner also, and very important other case, very other important aspects also, you see the Unicretion case is there, so which is also very important. And also certain other judgments, if you see, after the Menka Gandhi's case, also there are other judgments. Shankari Prasad's case was very important, and Minerva Mills versus Union of India was very important case. And Rudral Shah versus State of Bihar was very important case. ADM Jabalpur versus Shivakant Shukla is a very important case. So there are a lot of judgments. If we study in depth, it really enriches our knowledge. And once you start in a practicing arena, it is very important. We are taught, and as a practitioner, we should also understand that what is the wider jurisdiction. When we approach to the High Court, any High Court, under Article 226 of the Constitution, and in case if there's a violation of fundamental right, we directly have a remedy before the Honorable Apex Court under Article 32. So how the High Court has wider jurisdiction under Article 26 in comparative with the Article 32 of the Constitution. So these are very important things which we need to learn. We need to teach our students also, so that they have the deep and comprehensive knowledge, and once they enter into the profession. So I would say that we have gathered all today at a very auspicious and very relevant that we are celebrating this Samvidhan Diwas. The Samvidhan Diwas has its equal importance. It has equal importance because this day is a very memorable day that our Constitution came into force. It was enacted on 26 November 1949, but on 26 January, our Constitution came into force. The drafting Constituent Assembly, all the hardships which were done by the members of the Constituent Assembly in providing us with this Constitution is something of paramount importance. It has been my favorable subject. It has been my favorite subject because as a student, when I did 5-year course, I started debating on a lot of topics. I told you we had this Article 44 Uniform Civil Code under the Directive Principles of State Policy. We even passed this Women Reservation Bill. Now, of late, this bill was introduced in Parliament, but when I was in 3rd-year student, we brought this bill in our Model Youth Parliament, and I'm very happy to tell you that our team stood first amongst all the 84 universities which participated in the first Model Youth Parliament competition. And I was given the portfolio of Finance Minister and debater, and I spoke in favor of this Women Reservation Bill. But you see the Indian history. I still remember the chief guest of that function when we were having this seminar in the Constitution Club of India. Mr. Jaitley and Mr. Madanlal Khurana were the chief guests. Mr. Madanlal Khurana at that time was a parliamentary affairs minister, and he was so glad. He was so astonished. He said, "You have done a commendable job. You as law students have brought to the notice of the nation that how, in a very dignified way, the bills are introduced in the parliament, and then you have a hearing in the Lok Sabha and the Rajya Sabha, and then it goes to the Lok Sabha. But what is the state of affairs in our parliament? If you see in the government of India, you see in the parliament level, or you see in the state legislature, the bills are snatched, they are thrown, and it's a very sad state of affairs." So he was so happy when he presented us. He felicitated. He said, "You guys, you students, you budding lawyers, you students have done a commendable job in showing us that Model Youth Parliament competition, which will definitely teach a lesson to all our politicians that how we have to work, because people elect us, and you being representatives of us have to raise our voice. You have to raise the voice of the nation before, and then how the bill is introduced and it becomes an act." So my only submission is that it is a very important gathering today, and I think the message should go from my side to the MIT management that please focus on this subject. I would like that Sirvai Saab's books, HM Sirvai Saab's books, Shiva Rao Saab books, and DD Basu books should be introduced in the curriculum, in the syllabus, so that students should not take this subject lightly, because I've seen as a law students, what students do, they just, cram 7, 8 questions, 10 questions, and they pass exams. So that's not going to help them in future. So my respectful submission with folded hand is, you ask your students to study this special subject, which is of paramount importance, to go into the depth, study, do research, do what Supreme Court, just note down what Supreme Court has passed after the Indian became a republic, and recently. Recent judgments, if you see, the Honorable Supreme Court has passed numerous recent judgments in the Kambata Baligata Shraddh case, triple talaq case under curbing down 377. Lot of things have been passed. Drishti IS case in the, the court has expanded Article 19 and so on. I think I need a lot of time. If I'm going to speak, I'll speak till evening and evening. There are other panelists. Now I just pass out to you. Thank you, ma'am.
Thank you so much, Amit sir, for enlightening us, and your suggestions are of paramount importance for us, and we will definitely take them we will take them in our teaching, and definitely going to help us and to our students as well. Thank you so much, sir.
Thank you.
And now I would like to welcome Dr. Rupam Haldar, sir. Sir is working as an assistant professor at Ambedkar Government Law College, Pondicherry. He has also served as a junior research fellow at Department of Law, University of Calcutta. A very warm welcome, sir. Over to you, sir.
Thank you, madam. It is a very nice opportunity to be with you to celebrate this pious and auspicious occasion of Samvidhan Diwas, or the Constitution Day. So for me, for all of us, the Constitution starts with the preamble. But if you want to realize the more constitutional morality and the values enshrined in the preamble, definitely we have to study the preamble, we have to start with the preamble, but I personally believe we have to travel a little back, that in what situation, what socio-political scenario, the Constitution of India we adopted. So if you talk about then Mr. Attlee, the British Prime Minister, that the power should be transferred to the Indian hands by a date not later than 3rd June 1948. So a date has been fixed that the British government, they should hand over the power to Indian hands. They fixed up a date, that is the 3rd June 1948. And the declaration came from Lord Attlee, the British Prime Minister, on 20th February 1947. Impacting thereby, Indian Independence Bill was introduced in House of Commons on 4th July 1947. It secured the approval of both the houses of the British Parliament and was assented by His Majesty on 18th July, to be known as Indian Independence Act 1947. So whatever the concept of India today, we are very much proud of. It is a product of Indian Independence Act. Now the question is, if we compare the relevance of 15th August 1947 with the Constitution Day or the Republic Day, I personally believe, being a student of law, being a researcher of law, the value of 26th day of November 1949 or the value of 26th day of January 1950, it's much more higher than the value of Independence Day, 15th August 1947. So please pardon me. So I may be in some different footings to deliver my concept in this regard, that we got our independence through Indian Independence Act 1949. And if we go through the salient features of Indian Independence Act 1947, please pardon me. So we find the two independent dominion, India and Pakistan, shall be set up on 15th August 1947. So please, all the panelists and all the audience of this program, so please mind the word. The dominion of India was created in 15th August 1947. So independent India, what was its nature? By cover, it was independent India under the Indian Independence Act. But in reality, it was not the sovereign India. It was the dominion of India, which has been established and created in 15th day of August 1947, what we celebrate at Independence Day. And the most dramatic provisions of Indian Independence Act, it was the British paramountcy over the princely states would lapse on 15th August 1947, and each state would be free to join either the dominion or declare itself independent. Can we imagine what a blunder provisions they have incorporated in Indian Independence Act? So, okay, we can understand that we got our independence through this act, Indian Independence Act. but they made the provision in such a way by cover India is independent, but in reality, they wanted to rule us for 1,000 more years. So this is the point was taken into note by the Constituent Assembly members. So at least Dr. Ambedkar and his colleagues were there. They have taken this point seriously, that the dominion of India was created and established by Indian Independence Act. So what independence we got actually, it was a dominion, it was not a sovereign India. So the journey begins. So the actual Constitution Day, whatever we are celebrating, the journey begins, actual journey begins on that day, whenever the dominion of India has been created. And it was a sacred efforts of the Constituent Assembly to convert this dominion status into the sovereign, socialist, secular, democratic, republican status, to which we are very proud to be a citizens of India. So now we are not very proud about the dominion status, but we are proud what the Constitution of India conferred us. We, the people of India, have conferred us the status of sovereignty, socialist, secular, democratic, republican framework, right? So if the Constitution starts with the provisions of the preamble, I would like to take you the last provisions of the Constitution. And I feel and I believe without the provisions of Article 395, the Constitution as a whole would remain useless. So whatever Article 21 is there, whatever fundamental right is there, directive principle is there. So all other constitutional provisions by which we are feeling very proud of as a citizen of India, except without the enforcement of Article 395, which talks about repeal of certain previous provision. I read, the Indian Independence Act 1947 and the Government of India Act 1935, together with all enactments amending or supplementing the latter act, but not including the abolition of Privy Council Jurisdiction Act 1949, are hereby repealed. So that was the greatness. That was the Constituent Assembly member. They were so clever. They wanted to disconnect us from the British paramountcy. And the British paramountcy, they have cleverly introduced Indian Independence Act 1947, but true independence has not been conferred by this act. So it was the duty and responsibility voluntarily taken by the members of the Constitution Assembly under the guidance of Dr. B.R. Ambedkar that we have to disconnect this line. And how to disconnect this line? Only by repealing Indian Independence Act. So we are not happy with the dominion status of India. We need the sovereign status. From here, the journey begins. So please give due importance to repealing provisions of Article 395, which repeals Indian Independence Act 1947, hereby repealing the dominion status of India, hereby establishing the concept of socialist, secular, democratic, republic form of government. Now, if we are talking about the constitutional morality and constitutional values, which is enshrined in the preamble of the Constitution, which is reflected each and everywhere, each and every article of fundamental rights and directive principles, and which all together makes the guiding star of the nation. So now in this auspicious occasion of celebrating Constitution Day, being a citizen of India, if we ask ourselves, if we ask this question, have we achieved all the aspirations as it is enshrined in the preamble, as it is reflected in the directive principles, as it is there in the fundamental right? So we may not be satisfied with the answer, but I would like to say the journey has begun in 1949, 26th day of November. The journey has started. Still, we are in that way. Still, we are trying our best all together. We, the people of India, we, the citizens of India, we are trying our level best. Still, we are contributing for whatever part, whatever the duty we are doing towards the nation. whatever the responsibility we are serving towards the constitution to achieve all those goals, all those aspirations, as it is reflected into the preamble, as it is reflected into the directive principles, fundamental right and the fundamental duty. Although whenever we had our constitution, the provisions of fundamental duty was not there. So later it was incorporated into the constitution, but unfortunately, we talk more about the fundamental rights. We talk less about the fundamental duty. So in this auspicious occasion of celebrating Constitution Day, I would like to remember each of you, those who are associated with this program, about performing our obligation towards this Constitution by observing, by performing our duties towards constitution as enshrined in the fundamental duties. So we expect a lot from this constitution. 140 crores of citizens of India, we expect a lot from this constitution. But if question arises, who will fulfill the aspirations of this constitution? So whenever we are part of a team, we feel we have other team members that they will do. But whenever the responsibility comes to me as a single-headed, then we feel under trouble. So we have to realize this. So being a citizens of India, this is my right to have all the constitutional rights as well as fundamental rights or rights under directive principles. But we should not forget what is my duty, individual duty as a citizens of India towards this constitution. This is ultimately, end of the day, it is not the government, but it is the citizen which protects the constitution. So every responsibility, everything else, every duty, we cannot just only leave to the governments to do and we can have a trouble-free sleep. No. So please awake, please arise. We, the citizens of India, if we want to see India as a real Vishwaguru, whatever our Prime Minister have been telling since couple of years, so we can become the real Vishwaguru if we can realize our hidden potentialities as well. We can do oblige to our individual responsibilities towards respecting the constitutional provisions. So this is my humble message towards this Samvidhan Diwas. Thank you very much, the organizers, and thank you, Amity Law School, Noida, for inviting me as a panelist.
Thank you very much, sir. It was very well put. And I would also like to quote Justice Rajesh Tandon, sir, once said in a conference, have put it that, yes, the ultimate goal of India's intellectual background is to again gain the position of Vishwaguru as it was in the ancient days. And this is very well put that also I would like to appreciate this point of yours that fundamental duties have to be taken more emphasis now on, because we have been always being aware on our rights, but towards our duties, how we have to carry it forward, it is very important, and it has to be given more emphasis now onwards. With this, I would like to carry on this panel discussion, which is becoming so interesting with all of your opinions and perspectives on this topic. I would like to call our very respected Associate Professor, Dr. Santosh sir, whom we would like to hear on the same topic, that how sir put his opinions on this Constitution Day towards what should be our particular perspective and particular opinions towards this, and how we should bring forward this importance and relevance of this day. Sir?
Okay, Pranav, thank you very much for this particular participations. And my warm regards to Honorable Justice Rajesh Tandon ji, Dr. Sumitra ji, and Professor Bodhisattva Acharya ji, and my fellow colleagues, and ably represented by the Advocate Amit ji, Shruti ji. So all panelists have emphasized that particular part of our journey towards the achievement of the goals from the constitutional aspirations. And in the very beginning, Honorable Justice Tandon has also reiterated the various constitutional references representing the certain articles. And also all panelists have covered a lot of areas, in fact, including Advocate Amit has also demonstrated a very wide range of coverage of case laws. and has also emphasized the teaching aptitude regarding that particular constitutional cases. And at the same time, Dr. Rupam has amply made it very clear that you should emphasize not only to the rights and but also at the same time to the duties also. So this is very well done. And in fact, I would like to give my congratulations firstly to Dr. Sumitra ji for making this happen. The Samvidhan Diwas, earlier was Law Day, in fact. So when we were students, we were celebrating it as a Law Day, Vidhi Divas. But now it is turned up as the Samvidhan Divas, Constitution Day. So there is no change. Sometimes we take it as a synonym of law and constitution, and both are, I think, organic things, and they are always developed by the societal changes. So whenever we are concentrating regarding the documentation and articulations, so changes are always to be welcomed. Because as a philosophy, as the document is concerned, it is whole sacrosanct. But with the past 74 years, if we are counting from 26 November 1949, in fact, the draft has been there, and then implementation 26 January 1950 onwards. So we have recently celebrated the Azadi's Amrit Kal, in fact. So that has also given us the various challenges regarding the adjustments of the certain provisions and certain cases towards the changes as occurred. And this phenomenon has also posed a challenge not only to the legislatures but also to the public preaching fraternity, whole legal fraternity, that we should accommodate certain changes. And for that particular part, latest arrival is 106th Amendment that has been there at Nari Shakti Bandhan Adhiniyam, in fact, and that is going to be implemented as the futuristic approach, though that is debatable also. But here, there are certain highlights that is regarded a very potential changes. That one, in 2002, there was a particular mandate was given, like the Samvidhan Samiksha Ayog under the able guidance of the Dr. Our late Chief Justice M.N. Venkat Chalaiya ji. And he has also just examined certain things. And recently, uh, I will give few years, like one very pertinent scholar, though that is certain time representing the ideology of a party concerned, Vivek Dev Rai. He has written an article regarding that whether the changes are mandatory sometime, and he has written a very good article at that time, and he has just confirmed that we should be ready for the changes. But here, as a sacrosanct document and very old notions, as the advocate Amit has referred the Keshwanand Bharti case itself, the doctrine of basic structure. But here, it is always debatable that how we are going to solemnize that particular effort of basic structure. And certain times, if we are going to confront with that, the journey is sometimes is very much debatable itself. But happen to be the organic situation sometimes, like living organism as the constitution justifications. By this can be examined by the case law method, and the case laws have also given us the changing circumstances. If we are analyzing the case law from 51 to recent guidelines like A.K. Gopalan, there was very absoluteness at that time, high-handedness. But nowadays, we are taking it as an advantageous position for the human rights, natural justice, certain other rights. So lot of deliberations are there. So here, my point is that whether public aspirations can be done with staticness or dynamism. My vote for dynamism. By maintaining certain infrastructure, we have to be dynamic. Though philosophical norms, it is the grand norm, as suggested by the great scholar like Kelsen. So we can inspire ourselves by these particular grand norms, but like as the branches of the trees, if making we are very fashionable and cutting across it, then we can take the advantage of certain fruits by the changes. So like certain our demands as raised in panel itself, like Article 44, UCC documentations, and certain other changes with regard to the time, like your Justice Puttaswamy case and challenges posed by the social media, recent advancements like deepfake, artificial intelligence. So we have to be intelligent. And if we are very static in nature, we are not ready to overcome these particular situations. So please, just as an empowerment towards the changes, empowerment through changes are to be the caption for this particular long journey. And now onwards, we have to accommodate the lot of changes, not only for the rights, but aptly commented by Dr. Rupam ji from Puducherry as one of the great panelists, and he has suggested very well, not only we are capturing the rights, but we should also focus towards our duties as commandments, as the obligations put it then, and these 11 obligations as they must be taken as the fundamental towards governance also, and contribution of the every individual is warranted so far. So it is our prime duty to respect this and to respect the changes also, though with the discussion and debate, and we can take the advantage not only to the our legacy, our constitutional aspirations, but the technological changes are here to be welcomed and they are to be accommodated like Article 21's interpretation. As Article 20 is very organic in nature, when we are going to enforce it, implement it, but at the same time, its inferences are to be drawn with regard to the radical changes, not only in the society, but the economy, political thoughts, global changes, as G20 has recently concluded, and we have contributed a lot towards that particular phenomenon. And at the same time, for these technical transformations and the challenges, we have to adopt the changes in our constitutional documentations also. So my vote for that particular celebration of the constitution, not only with the staticness, but with the dynamism, and ready for the our personal contributions and our personal regard to this particular constitution, to obey the commandments. And with that, my great thank you and warm regards to again for the organizers and Dr. Sumitra ji especially. And I think that this should be done in a series manner. My suggestion is that you can follow a series of discussion like Friday talks, Wednesday talks, Monday talks. So that will be very easier us to deliberate our discussion and contribute towards the betterment of not only to the society but ourselves also. So please take note of my suggestion. Thank you very much for giving me a chance to just fair enough to comment also on the panelist view and my all well regard to the constitution also. Thank you. Thank you very much.
Thank you so much, Santosh sir, for enlightening us. Now I would like to welcome Professor Dr. Bodhisattva Acharya sir. Sir is serving as a Director of Amity Law School at Amity University, Raipur. Sir has also served as a Dean of the College of Law at IIMT University. Sir has also served as an international arbitrator for almost 10 years. Very warm welcome, sir. Over to you, sir.
Thank you very much to my learned friend Dr. Sumitra ji, my younger brother, Dr. Santosh Kumar, and the other esteemed panelists, and above all, I am overwhelmed and that I am sharing the screen with Honorable Mr. Justice Rajesh Tandon ji. Namaskar, sir. We all discussed about the Indian Constitution, about the rights, about the duties, about the fundamental right, about each and everything. And I would like to say that I am not the expert on Constitution because my area of interest is jurisprudence. So I would like to discuss about why a Constitution is important for a country, if you allow. So
You
So-
proceed on your own way. Jurisprudence is applicable in all the ways, even in the constitution. Jurisprudence is very important. Without
Yes,
jurisprudence, no constitution can be framed, at least.
Exactly. So I would like to start that when the constitution was started, the journey of the constitution started. So there have been 14 Manus, and among them, Vavast Manu wrote the world first constitution, which is known as the Manusmriti, and which is thousands of year old. The constitution, but in the modern era, if we go through the history of the constitution, then we know and we just have the knowledge that the world's first constitution in the present time, that is the constitution of San Marino, and which has been considered the oldest active written constitution in the world, because some of its main provisions of this document are still in existence from the date back to the year 1600. While the Constitution of United States is the oldest and active codified constitution, and the Constitution of America has been considered the most stringent constitution in the world, while on the other hand, the Constitution of Britain is the most flexible constitution. Basically, constitution is the law which is the basis of the governance of a nation, determines its character, its organization, it prescribes its method of application. Therefore, it can be said that a constitution is the supreme law of the nation and enjoys a special legal status, and all the existing laws of the concerned state must necessarily conform to the spirit of the constitution, and if they would violate it, so then they are liable to be declared as unconstitutional. And we see that there are so many laws. Honorable Supreme Court has declared the unconstitutional, and the which are not following the especially soul of the Constitution of India. So the Constitution is a fundamental law that outlines the rules for governing the country, determine the structure and the functions of various organs of the government, and protecting the interest of the citizen. The Constitution is the power which, in the first place, creates the government. The second function of the Constitution is to make it clear who will have the power to take the decision in a society of the concerned the country. The Constitution also decides how the government will be formed, how the people of the state will form the government. The basis of any republic or democratic country is the constitution, in which all the rules are made by the important persons or a group of the people or that country or nation to run the administration by separating the powers in a proper way of the country, so that misuse of the power can be prevented. Through the constitution, the basic but very important power is vested in the people. There are due to which, if any wrong person reaches to the high point of the power, then definitely he can be removed from the post. So basically, the main functions of a constitution of a country is Number one, to clarify the objective of the government. Number two, to clarify the structure of the governance. Number three, to protect the rights and the freedoms of citizens. Number four, to set the duties of the citizens towards the concerned country there where they are living. Number five, providing ideological support and legitimacy to the state. And lastly, to create an ideal governance structure with a vision of the future. Basically, constitution is a very important document. And in my opinion, constitution always protect the citizens, always protect the rights, always protect the fundamental right. Or it is very important. And there are so many bodies in a state. They are established to protect the rights, to protect the duties, and to convey what the constitution needs from the citizen of a country. And I would like to conclude my words in a sentence of the great Aristotle. Aristotle has rightly said that elude natura conditio habitus de civitas ad imperium per statum or salus populi suprema lex est constitutio. It means that the nature, the conditions, the habits, or the welfare of the people has been controlled by a supreme law, and that is known as the Constitution. Thank you.
Thank you very much, sir, for such intellectual words over and light over this topic. Now, moving forward, I would like to call our next speaker for this discussion. And I am thrilled to introduce our next esteemed speaker, Ms. Rachna Gandhi, Advocate, Supreme Court of India. We would like to hear your perspectives, ma'am, on how Indian Constitution has shaped democratic values and governance, and what are the present challenges which are being faced.
Oh, I think Rachna ma'am is facing some problems. So in the meanwhile, can we take up a few questions, Pranav sir?
Sure, ma'am. Sure, we can proceed.
Okay. So there is one question for Advocate Amit, and together with Dr. Haldar. The question is, the question is very simple, but complex in some way also, because it is asked from the perspective of a layperson. Somebody's mic is on. Okay, so Amit sir and Haldar sir, the question is, a student says, ma'am, we understand that the preamble is the soul of the Indian Constitution. It says, we the people of India having solemnly resolved to constitute India in a sovereign social secular republic and to ensure secure to all the citizens. The student is asking, how do we know about the validity of these words? Don't find justice everywhere across the country. I don't see that our country is highly secular. It is mentioned in the preamble. I mean, all those words. The student is questioning each and every attribute of the preamble. So how does it go, Advocate Amit? Over to you.
Actually, ma'am, I initially started, I told you that Indian Constitution is a blend, if you see. We have got some from Sweden, we have got some Britain, US and all. And after, the blend of all these countries, we have drafted this constitution. So since I, as a student, I have also been debating on a lot of the provisions on the articles of the constitution. So each and every, provision if you touch is of a higher debate. I think the student, he's a budding lawyer. Will he be a good lawyer in future? He's rightly touched and asked a good question. But, each and every provision of the constitution, each and every article of the question, it is debatable. You have, as you see, now there are two sides of a coin. There are two wheels of a cycle. So obviously, it's all debatable. I told you Article 44 in the Directive of State Policy, Uniform Civil Code. Now, if we have very recent, I think very soon, the government will be bringing this and it has been in their whole manifesto of BJP since long, and I'm very sure they're going to bring before 2024 elections. So that is also a very debatable topic. So there are a lot of provisions that they are all debated, but the Constitution being the supreme law of the land. So the basic structure is, the body, and each and every word which is there in the preamble, you see in totality of the Constitution, it has all significance with the preamble. That is why in the landmark judgment of Keshwanand Bharti versus State of Kerala, the 13-judge bench of the Honorable Supreme Court said it is not easy. It is not easy to amend the basic structure of the Constitution. And for that, since there was a panel of discussions, there were a lot of debates and all, and even the views, you see the views of 13-judge bench. There were dissenting views also. How can you adopt this doctrine of this Constitution? How can you basic structure touch the basic structure? It's not easy, because the entire crux of the Constitution of India is given under preamble. So majority judgment prevailed in the Keshwanand Bharti case, but you saw if you go into the depth of the judgment, Justice S.M. Sikri said something, Justice Shailat Grover said something, Justice Hekde, Justice Mukherjee said something, Justice Jagmohan Reddy said something, Justice H.R. Khanna said something. So, but the significance is that this is a preamble which has the crux of the Constitution. So each and every provision, undoubtedly, it's a debatable topic. It's a debatable topic, but I think basic structure is something of very paramount importance, and the entire crux of the Constitution relies upon that basic structure, which has been very well. Ask your student to go into this vacation on Bharti versus State of Kerala in depth. That is why I emphasize on this. Ask the student not to just brush up with the questions of constitutional law, just to study 10, 12 questions, 15 questions, 20 questions. You pass on an exam, that will not fetch you anything in life. Because, as a student, when I was studying, I used to study D.D. Basu at length. My fellow students, all my friends said, "Yeah, pagal hai yaar. He keeps on studying in the library for hours and hours." Because I used to study because I started mooting from the second semester onwards. When I have studied the law, I was allowed to go for the national moot court competitions to Kerala, Goa, and Afro-Asian at Bangalore also. So this subject, something is of paramount importance. So ask your student to go into this very relevant judgment of Keshwanand Bharti in depth. He'll get the answer to all his queries, I suppose. Thank you.
Thank you, Advocate Amit. Now, there is another question for the educationists here. The question is directed to Dr. Rupam, Dr. Santosh, and Dr. Bodhisattva, sir. The question is, the student says, I've read justice, the preamble says that it's going to secure to its citizens justice, social, political, and economical. The student fails to understand what is economic justice, what is political justice. He has heard about social justice, and how can that be equated? Over to the eminent educationists of the panel, Dr. Rupam, Dr. Santosh, Bodhisattva, sir.
Okay, thank you for this question. So I would like to say the student, this question came, I would like to thank the student that the student came to the student's mind. So unless and until question is coming, we imbibe to the questions automatically, so we can't learn anything else. So I always say to my students that unless and until you can make a question, you can't learn anything, because learning starts from questionnaire, learning starts from questioning. Now, the question is whether if we ask the validity of the constitutional provisions or the preambular provision, that the whether justice, social, economic, political, so this is a valid concept, or in other way, did we achieve or have we achieved the justice which is termed as in the preamble social, economic, political? So probably the student is asking either of these two concepts. So if I would like to answer, see, please try to understand the preamble with your questions. What is a preamble? It is in a form of a declaration. And what is the form of declaration? It was in form of a resolution. So for example, whenever I was a student, after the end of every semester exam, I used to take a resolution that next semester I will do better. Every new year, we used to take a resolution that whatever the fault we have done in the last year, we should not repeat it in the next year. Similarly, 1949, 26th day of November 1949, we the people of India, we took our resolution, resolved to secure to all its citizens justice, social, economic, political. So if we have taken a resolution that we have to achieve this, that means it implies at that time these three things were not available in totality in our system. We have been deprived of by the British administration system. They have deprived our justice system. That's why we were socially deprived. We were educationally deprived, politically deprived, economically deprived. So whenever we had our own constitution and we the people of India, we had to decide our own fate. We have decided that we will ensure justice, not to a particular citizens, irrespective of religion, race, caste, sex, place of birth. To whom? To all the citizens of India. What type of justice? Social justice, economic justice, political justice. So what do you mean by social justice? Eliminating all the social inequalities which were prevailing in Indian society since time immemorial to the adoption of the constitution. So if you want to achieve the goal of Indian constitution, so we have to eliminate all inequalities, all injustices which is prevailing in our society. So that is the one concept of social justice. So for example, the equality in every sphere of life, elimination of untouchability from our society. This is an example of social justice. Similarly, if we talk about the political justice, so our Constitution of India, it is based on the concept of political justice. Had the Britishers given Indians a permission to enter into the British political system, so Britishers could rule India for another 100 or 200 years. So the political participation in the ultimate administration, it was not there. So what we talk about the constitutional polity, so do we have an active role in there? Can we participate in the constitutional polity? So if we look into before 1947, all the Indians, they were not permitted to enter into the constitutional polity. But this Constitution of India gives you that much of freedom. Anyone else, so you are free, you are part of the Indian polity. So there is no discrimination on the basis of caste, religion, sex, and all these things. And if we talk about the economic justice, so that means there should, in 1947, what we realized, what we have seen, there is a huge imbalances, economic imbalances. Only the few percent of the society, all the wealth are concentrated to them. It is still truth in India that 95% of Indian wealth, it is concentrated to 5% of Indian citizens, and only 5% of Indian wealth, it is concentrated in the hands of the 95% of the Indian population. So still we have miles to go to achieve the economic justice. But what if we compare the concept of economic justice in 1947 or 1950 with 2021, we can see a dramatic change. We can see a drastic change. We can see all of us at least are better positioned to be economic empowerment. So nowadays, government, all central government and all the state government, they are bringing so much of schemes, economic schemes, to empower its own citizens. So if we look into the directive principle, Supreme Court of India time and again said, existence first, then development. So if I don't have my human existence only because of the economic scarcity, how can I cherish the fundamental rights of the citizens of India? So economic justice, economic rights is most important. And last 30 years, government of India is giving so much of importance to make all the citizens economically empowered. So if we are economically empowered, then only we can cherish our fundamental right. Although we didn't achieve this economic sorry, but I can say we have traveled a lot to achieve this justice, social, economic, political, at least much more better than the situation in compared to 1950 and 2023, where we are standing. Over to you, ma'am.
Very well said, Dr. Rupam, very well said. However, I would like to further ask Dr. Santosh, sir. Sir, can you delve more upon what is economic justice? The student who's questioned this, he fails to understand. He says that there is so much of, he sees that there is so much of economic inequality. And in the constitution, we are talking about economic justice. Do you think this particular venture into creating a $5 trillion economy will also help a layperson like the people who we help in the legal aid society? Over to you, Dr. Santosh Kumar.
Yes, that will definitely going to contribute, since as adoption of the constitution has given a welfare state mechanism, and the welfare of the people, in fact, And basically the doctrine of distributive justice has been there through the interpretation and the constitutional provisions. So the government is taking the effective steps for the parity of the economic distribution, not only with the policies but also the mechanism. Like your Niti Aayog has formulating lot of policies. Earlier we have got the Yojana Aayog, Planning Commission, in fact, that was taking care of the lot of policies of the government towards the welfare measures and economic distribution. And likewise, our Honorable Prime Minister has also emphasized that particular public welfare. That's why the Lok Kalyan Marg is there in Delhi, in fact, for that public betterment and public distribution. So lot of schemes which are there by our banking, non-banking systems, government systems, are just for providing relief and making some parity towards the welfare schemes and the economic distribution. So sometimes it is not very much measurable, but in a long run, it is contributing. As Dr. Rupam has aptly described that particular distribution, in fact, one example can be cited for the to the students as the right to property. In fact, Article 31. If we are reading it academically, now that is no more a very good fundamental right. In fact, that is had been converted to the legal right, and that is only for the economic justice, for the welfare of the public, not only the public but the welfare of the nation also. Acquisition of land, new land rulings, and new particular schemes for the acquisitions, and then distribution for the industry, for the educational setups, in educational institutions, residential accommodations. These are the economic activities. So not only this is catering the individual needs, but also the societal needs. So in a comprehensive manner, our policy towards that public welfare can be measured, and this is a continuous journey, though certain are lacunas in there, like ill wills and other ill effects, like disease in the body. There are certain diseases, and the government is making it hard to accept that there are to be cured. And recently, the government has also devised certain plans like your DBT schemes, direct benefit transfers. It is one of the most recent development that you are getting your money in your account, not only to your account, but also to the benefits who are the real beneficiaries. Once Rajiv Gandhi has stated that is single rupees if distribution, then 1 paisa or 2 paisa or 5 or 10 paisa is reaching to the ultimate individual. So that was cause, but this is the real issue, and the economic distributions are certain times not visible directly, but they are going to be adjusted with regard to the public need and public welfare, and not only for the economic justice but also for the social justice also. So economic justice a very wide term, not only framing for the individuals, but certain times it is for the whole society, whole nation. And by these welfare measures, we can achieve this in, let us hope, by 2047, as the government is expecting and policies are under making, we can achieve this target and public aspirational economic distribution, economic justice. I think the student will able to comprehend this particular answer by this particular my view. Thank you.
Thank you, Dr. Santosh, sir. Actually, we've got 2 to 3 more questions, but our another panelist has joined. Other questions are directed to Advocate Amit and Justice Rajesh Tandon. We will take up 2 to 3 questions later. But now we have Rachna Gandhi joining us. She's an advocate at Supreme Court. I'll request Pranav sir to invite Rachna, ma'am, please.
Yes, it is to our privilege that our esteemed guest has joined. I would like to welcome Ms. Rachna Gandhi, Advocate, Supreme Court of India. And ma'am, we very much welcome you to this panel discussion, and we would like to hear your perspectives on how Indian Constitution has shaped the India's democratic values and governance, and what are the current challenges which we are facing or looking towards, and what are the relevance measures that we can take towards addressing those challenges. Over to you.
Thank you, Sumitra Madam. Respected Honorable Justice Rajesh Tandonji, former judge, distinguished colleagues of Supreme Court, Dr. Sumitra Singh, Dr. Shruti Bist. I'm really thankful to all of you and Amity University. They invited me here on this occasion. So I would like to share my perspective on right to life with human dignity. This is the concept. It is given in our constitution. I would like to focus on a very important case. It is Maneka Gandhi versus Union of India. This matter, the Supreme Court gave a new dimension to Article 21. The court held in this matter that the right to life is not merely a physical right, but includes within a ambit to the right to life with human dignity. Elaborating the same view, the court in Francis Colloquium versus Union of Delhi, it held that the right to life include the right to live with human dignity and all that goes along with it, with like bare necessities of life, like clothing, shelter over the head, and facilities for reading, writing, expressing oneself for diverse forms, freely moving about and mingling with fellow human beings, and must include the right to basic necessities for basic necessities like life, and also the right to carry on functions and activities as constitute the bare minimum expression of human self. Another bold formulation of the life to dignity is found in Bandhua Mukti Morcha versus Union of India. So, in Maneka Gandhi versus Union of India, the Supreme Court, it includes so many things. Like it is very much important. Like everybody needs shelter and food. So the perspective given in is like no person shall be deprived to be of his life of personal liberty except according to procedure established by law. Life in Article 21 of Constitution is not merely the physical act of breathing. It does not connect mere animal accidents or confirmed through life. It has much wider, including the right to life with human dignity, right to livelihood, right to health, right to pollution-free air, etc. So, in fact, I would like to conclude my these things here, and thank you, Sumitra ma'am. Actually,
Namaskar.
Notice I'm unable to handle so many things here.
It's fine, Rachna ma'am. You joined. I'm very thankful to you. आपका matter है, मुझे पता है अभी.
I'm sorry.
आपका matter है अभी. नहीं, I know that you have to appear in a matter. Justice Tandon is here, and he is also very happy that despite having a matter, you came for us for our event. Thank you so much, Rachna ma'am.
Thank you, and thank you all of you. Thank you so much. Okay. Yes.
Pranav sir, over to you. Trapti ma'am.
Yes, ma'am. I am online. I got some fluctuation in the network. Sorry for that.
Thank you so much, Rachna ma'am, for your enlightening words. Now, I would like to welcome Mr. Jiten Singh, sir. Sir is advocate at Supreme Court of India. Sir is also a president of All World Gayatri Parivar. I would also like to mention that sir has supported our Legal Aid Society during pandemic. A very warm welcome, sir. Over to you, sir.
Honorable Justice Tandon sir and Sumitra ji and other my respected colleagues and faculty members, students, it is a very good opportunity for all of us to introspect so far as our duties and fundamental duties are concerned.
आप बहुत देर से आए, कहीं कहीं दूसरे प्रोग्राम में लगता है लगे रहे हैं, बहुत लेट आए आप.
Sir, I tender apology for that because my matter was listed in court number 15 and it was passed over. Thereafter, State of UP Council Garima Prasad came, then it was heard, and I am just coming after completing the matter. So that is the reason I could not join in time. But be that as it may, I respect you all for joining this meeting, particularly on the fundamental principles which were evolved by the Constitution. And the Constitution is a very revered document for all of us, for rule of law, for supremacy of law, for the basic structure of our jurisprudence. That is our Constitution of India. Before I start, I would say that as the Constitution was earlier, and we adopted it on 26th November 1949. You all know the words which were put in the preamble of the Constitution, which says, "We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular." Earlier it was not mentioned, but the impression and meaning was there clear that it should be a socialist type of governance, and it should be also secular fabric. And it shows that from judgments of Supreme Court that they interpreted that this is a very harmonious arrangement in the Constitution, and the constitutional framers as well as the honorable judges, while giving interpretation to the constitutional provisions, they have categorically and time and again have kept themselves within the ambit of the Constitution's correct meaning and interpretation. The example is that liberty was there earlier in the preamble, and that liberty and dignity has been time and again stated by the Honorable Supreme Court and High Courts in several judgments. That liberty does not mean liberty with animal existence, but liberty with dignity, assuring the dignity of every individual. So justice, social, economic, and political is required, but at the same time, it should be with the dignity of the assuring the dignity of every human being, every citizen of India. So I must also point out the requirement of and importance of the duties in our day-to-day life. And without duties, performance of duties, it would not be possible to make the Constitution a successful document. And you know what was said by one of the Constitution framers at the time of inauguration or declaration of this Constitution, that if a defective Constitution is there and the for generations to come are so much good, then they will prove this Constitution a good Constitution. But if this is a perfect Constitution and the generations to come are so much valueless, then they will prove a very perfect Constitution a dysfunctional Constitution, a defective Constitution. So what they said is important and relevant today as well, that their idea and their impression and their view was very clear that it depends on the generation to come. They will decide as to how, and that is why the power of amendment was given in the Constitution. But this power of amendment was sometimes not used in a proper perspective. By first amendment itself, it was stated that the certain amendments of the Constitution will be immune from the judicial review. That has been categorically assessed by the Honorable Supreme Court is the largest and celebrated judgment in the Kesavanand Bharati's case, which has been again in several other cases and recent decisions have been cited, followed, and considered. Now, I would say at this occasion that what we have to do, we have to have our own view. We should read the Constitution. Constitution is as pious and as good as Gita and Bible, Quran, and other scriptures. It is the main source of living main source of living of these constitutional institutions. They perform, they function because of the Constitution. If the Constitution is not there, they will not be able to function properly. And it is also against the autocracy or monarch that system, and that has been replaced by the Constitution of India. So the question earlier arose in Henry Keshav Singh's case that as to whether which organ, whether legislature, executive, or judiciary, which one is supreme? Then the Honorable Supreme Court, in the reference, categorically decided this question that neither the judiciary nor the legislature or nor the executive, but it is the Constitution of India that is supreme. And we have the supremacy of law has been accepted in that judgment, and accordingly, the Constitution is on the highest pedestal of legal arena, and all the laws are from they have source from the Constitution. They merge into the Constitution and they appear from the Constitution. They are interpreted as per the will of as per the terms and provisions of the Constitution. So this is an occasion to assess individually, collectively, and it is a very great privilege for me that I have been invited for giving my views in this August gathering. I request you to continue this pious job and particularly making aware the citizens of India, we the people of India. Thank you.
Thank you, Advocate Jitendra sir. I know you are busy in the matter you are presenting in the Supreme Court. Thank you so much for taking out time. Rather, Amit sir also had so many assignments and engagements. But now that both of you are here and also Amit, Dr. Rupam is here, this question is directed to both of you in the same breath because this question is taken up from the preamble. Sir, can you tell me and define me, redefine me, and assure me that I truly understand the meaning of these lines? And the lines are, the preamble says, equality of status and of opportunity. In the same breath, the other sentence, fraternity assuring the dignity of the individual. The student is curious to understand the meaning of these two lines because he doesn't see this happening in the society. Over to you, Advocate Amit and Advocate Jitendra.
Yes, ma'am. See, the student has a very valid query because, you know, as a student, your brain is developing and later on you become budding lawyer. So it's a relevant query. See, his question is equality of status and opportunity. If you see Article 14 of the Constitution, it says everybody is equal before the law. Test of reasonableness is there. There is no discrimination on the basis of caste, sex, caste, and all this. So before law, everybody is equal. So that is the reason being, if you say equality of status and opportunity, fraternity assuring the dignity of the individual. Now, the main thing is the dignity of the individual. As we have in the panels, we have had a long discussion about Article 21, the expansion of Article 21, right from Menka Gandhi's case, you know, to live with human dignity, to live with pollution-free environment, to live with your reputation, like and all. It's broadly, you know, this landmark judgment of Menka Gandhi has broadly expanded the scope and horizon of this Article 21. So if you correlate it with Article 14, it says that before law, everybody is equal. Equal treatment to all. Equal treatment to all. That is what the answer of this question is.
Yes, sir. Very well articulated. Advocate Jitendra Singh, sir, would you like to share some perspective on this?
Really, Article 14 gives you right to equality and equal protection of laws. And my learned friend has categorically stated about this, that there is, in order to give the equality criteria, and there should be a test, intelligible differentia, and the differentia should satisfy the objective of the legislation. So in order to complete these two aspects and to satisfy these two tests, the government, the legislature has to make the law, and the law, source of law is constitution, and the constitution protects the fundamental rights and right to equality. And again, there is another right, the state shall not discriminate on the basis of caste, creed, sex. And there is also provision in Article 16 as well, which gives you equality of opportunity in employment. And these two articles give you general impression that equality is everywhere and equality should be followed. But they give some immunization for the legislation which are made for women or for other backward classes. And so far as educational institutions admissions is concerned, or the employment in the public sector is concerned. So they have given the theory of, suppose so many persons who were not given education and their families are, and even the caste system was so that some particular castes were criminalized, and it took time, and after independence that was continued. So some caste criminalized, and thereafter they decriminalized, and thereafter their position was very vulnerable. So in order to satisfy the will of and the people of the India, they made the arrangement of the reservation, and initially it was for 10 years. It was initially for 10 years, but it was again extended and extended. Now it has become the the way of life and the need of the political parties as well. But there is a need to actually assess the situation, which was earlier different when the constitution was enacted, adopted, and was given to ourselves. And we are completing more than 75 years, and 10 years time is a very long time. And now 75, 76 years is a very, very long time. So we should consider all these aspects. And I think the question is very, very wise enough, and it should be considered at length by the respective authorities. Thank you.
Thank you very much, sir. As we proceed further towards the conclusion of this discussion, I would like to request now our Assistant Professor, Dr. Kavita Sharma, Madam, to present the vote of thanks.
Good afternoon, everyone. I, Kavita Sharma, on behalf of MET Legal Aid and Literacy Committee, extend my sincere gratitude to all the panelists. And I would like to thank Professor Dr. D.K. Bandyopadhyay, sir, Chairman of MET Law School, Professor Dr. Aditya Tomar, sir, Additional Director, Joint Head of MET Law School, Professor Dr. Shefali Raizada, ma'am, Additional Director, Joint Head, MET Law School, and Arvind Bhanu, sir, Additional Director, Joint Head, MET Law School, and also Honorable Justice Rajesh Tandon, sir, Additional Vice Chairman, MET Judicial Academy and MET Law Foundation, and the other panelist, Advocate Dr. Shruti Bisht, ma'am, Advocate Jitendra Singh, sir, Dr. Rachna Gandhi, ma'am, and Advocate Amit, sir, Dr. Rupam, sir, and Dr. Santosh, sir, and Professor Bodhisattva Acharya, sir. And I would also like to thank Sumitra, ma'am. And also, I would like to extend my gratitude to Pranav Tiwari, sir, and Dr. Trapti Vashne, ma'am, and all other faculty colleagues who have joined this online colloquium. And I would also like to thank all the students who have taken time from their busy schedule for their their exams are going on. So thank you everyone for deliberating on the occasion of Samvidhan Diwas. Thank you all.
Thank you, ma'am. As it have been a very privileged day as we all came together to honor the essence of this remarkable document, I now would like to call Associate Professor Dr. Sumitra Singh, ma'am, for the closing remarks of the session.
Thank you, Pranav sir. Well, everybody, it was a great session. But at Amity, we say that Amity is as good as you make it, and wherever you go, your name with Amity will remain forever. So today, all the panelists who joined have become Amitians. Thank you so much. And it is said, our founder president, Dr. Ashok K. Chauhan sir, believes that every Amitian is an asset to the society and the nation, and every day, following his values and ideals, all the students of Amity Law School Noida are soaring great heights, and it's my proud privilege to inform you that today Amity alumni are there. They are spread across the globe, and they are trying to build the society of their dreams. And what is that particular dream? And that dream lies in the heart of every Indian, that India has to remain a Vishwaguru. And in the contemporaneous times, as we can see, with the science and technology ruling the roost, how India is growing very fastly towards a growing nation, a developing nation, getting into the matrix of a developed nation. That will be, I think, one great thing in which we all will pursue all our dreams. As Honorable Prime Minister says that you have to dream 25 years hence. So I think we all will be there to see what will happen 25-year hence. And 25 years from now will be the India of our dreams. We have to build our nation. Together we have to build a nation. It's not just Sabka Saath and Sabka Vikas, it is also Sabka Vishwas. So thank you so much, everybody, for joining us in this colloquium. Amity Legal Aid and Literacy Committee thanks everybody with a heart full of gratitude. And on behalf of our founder president, Dr. Ashok K. Chauhan sir, and our committee head of Amity Legal Aid and Literacy Committee, Dr. Aditya Tomar sir, goodbye and God bless everybody. So Maksud sir, we can now end the session. Bye-bye, everybody. Take care.